We can't rush to judgment.
Glynn County Interim Police Chief O'Neal Jackson says the investigation into the brutal mistreatment of 19-year-old Trent Learcamp will not be solved overnight.
We owe it to this victim and to his family to make sure we get it right.
Learcamp was dropped off at a hospital in Brunswick the night of March 21st after attending a party at this house on St. Simon's Island. He was soaked in urine, covered in spray paint, and had a blood alcohol level nearly 6 times the legal limit. A picture posted on social media showed Learcamp unconscious and bound to a chair prior to being taken to the hospital.
If a picture could say 1,000 words, then the 1,000 words that picture would say was, that's a horrible incident that occurred.
Detectives have identified the 9 minors who were at the party. Chief Jackson says none of the teens did or said anything to stop what was happening to Learcamp.
In our society, we should have a zero tolerance for bullying and the mistreatment of others. That goes for any student, that goes for any parent, that goes for any adult. And all I could ask is that when you see something, you have to say something.
While no one has yet to be charged, Chief Jackson says nothing's off the table.
We're looking at this investigation from a holistic point of view. Not only the parents that the home that this occurred in, but we're also looking into where the alcohol was obtained from, as well as any type of narcotics.
Zach Summers, Atlanta News First.
And that was our Zach Summers taking you to a bullying investigation story out on St. Simon's Island in Glynn County. Now, this is a story we've been following for weeks since it first took place, the incident, March 21st. We since learned yesterday that 5 people are facing charges, 2 adults, 3 teenagers. One of those teenagers named because they are 17 years old, and in the state of Georgia, you can be tried as an adult at 17. Now, we are taking you beyond the headline to talk about some of these charges that had a lot of people scratching their head when you hear the story. I want to bring in Andrew Fleischman, attorney and partner at Law, to talk a little bit about these charges with me. Andrew, thank you so much for joining us here. Some of these charges I'm going to read out loud. The first 2 for the adults that were arrested, 46-year-old man and 56-year-old woman facing charges of maintaining a disorderly house and contributing to the delinquency of a minor. When we talk about a story of bullying and what many friends and family described as torture and a mistreatment and something that is cruel and unusual, and then we hear misdemeanor charges, is this unusual for a case like this?
Well, I mean, based on the facts we know, what the parents are accused of is having drunk kids in their house. And that's delinquency of a minor, or it's maintaining a disorderly house. You don't see too many disorderly house charges, in part because it's hard to prove. You have to show that this wasn't a one-time occurrence, but that it was customary for kids to drink at the house. That's not always easy.
And, you know, we talk about the other charges that were also on the misdemeanor side of things. I'm going to read those. The 2 juveniles who will remain unnamed, simple battery, criminal trespass, and possession of drug-related charges. Now, we do know from the district attorney of Glynn County that those 3 teenagers were the 2 teenagers were the ones to take the victim to the hospital. And what we since learned was that they were at that party where this alleged hazing and bullying took place. Now, the DA has since said that a lot of misinformation clouded this investigation. So I want to talk a little bit about these charges, the simple battery, criminal trespass, and possession of drug-related charges, and how when we hear about a lot of the misinformation that was present in this case, as the DA said, how that is connected to all of this.
Well, those are relatively minor charges, really reflecting sort of just touching someone without their consent. If you draw a shape on someone's face when they're sleeping, that can be battery. So these are not terribly serious charges. What really strikes me, though, is the possibility these kids might have an affirmative defense. Typically, if someone is overdosing or having a medical event and you call police to deal with that, whether it's alcohol or drugs, you are protected from arrest, and so is the person who is overdosing. So it'll be interesting to see if they raise that defense here in this case.
And we're talking with Andrew Fleischman. We talk about this bizarre investigation. A lot of people really trying to decipher between what the evidence indicates based on the charges being presented and a lot of what was being spread surrounding this story. There were original reports that have since been debunked by Glynn County Police, by a Glynn County District Attorney, that the victim, Trent, had autism. That was, they say, is no longer true. That he was urinated on, they say that is no longer true. A lot of those details that were shocking to so many people but didn't lead to charges because further investigation has debunked some of those facts, or I should say not facts in the case. We want to talk about the juveniles not being named. Of course, that's in accordance with Georgia law, but these types of misdemeanors, they cannot be elevated. Is that correct?
Elevated, what do you mean? You can't try them as adults for misdemeanors?
Right. For these types of misdemeanors, if we're talking about taking it to, superior court or pursuing it further for an investigation like this, I do believe that they do come with a certain limitation on how far an attorney can take these charges.
My understanding is that typically you cannot charge juveniles and adults on misdemeanor charges. There are some exceptions for felonies, particularly serious felonies, where it's almost automatic. And what that means is that oftentimes you get to the same resolution, but with a different sort of process through juvenile. They're unlikely getting kind of jail time. There is the possibility of like a juvenile detention facility, which is plenty unpleasant, believe me. It just changes the range of possible sentences. But here, this sort of seems like a pretrial diversion case anyway. I doubt they would do any serious punishment.
And we talk about the teenagers that are now facing charges in this case. The fact that they took the victim, Trent Lerkamp, to the hospital, did that contribute to a lessening of charges? Is that something that attorneys usually consider?
Well, sure. You have the possibility of sort of cruelty second charges or reckless conduct charges. And when you take affirmative steps to keep somebody safe, those charges are no longer really available in the same way. There's some pretty interesting Supreme Court of Georgia precedent about how reckless you have to be criminally negligent, and it's a high bar. Also, as I mentioned earlier, when you bring someone to the hospital or you call 911 because they're overdosing, that can create an affirmative defense of charges built around those overdoses.
And we talk about this investigation. Clearly, so many people now following it has taken statewide attention, and that puts a lot of pressure on the legal implications involved. You know, when you have public outcry like that, what can we expect next in this case from a legal standpoint?
Next, there'll be probably an arraignment or an accusation, depending on who we're talking about for the adults. You'll probably have an accusation in state court. My guess is they'll probably plead to it for a small fine and put it behind them. That has a number of advantages. For one thing, the case is over. It doesn't cost a lot of money. It also makes it hard for the state to later bring more serious charges unless they find new information that justifies those charges. So that's a good protective measure. Kids will go to juvenile court, and again, those proceedings will not be very easy to observe. So we probably won't hear much more from them about it.
And we did hear a statement from the family of the victim, the Lerkamp family, saying that they were taken by surprise by that press conference yesterday, by the misdemeanor charges. Can there be any legal pursuit that they can take either against the police department, against the DA, in their decision to pursue misdemeanor charges?
Prosecutors enjoy what's known as absolute immunity, which means they can't really be sued for anything they do in the course of their duties. Police officers have qualified immunity. That means that they have to be violated the Constitution, and there has to be a case right on point saying it's a violation. All this to say, really nothing you could do against the police in the exercise of their discretion. Even under Georgia law, that's not permitted. But you could, of course, sue the family for negligence. You could sue the other kids for battery and say that the parents are responsible. Go after the homeowner's insurance. There are ways that they can seek compensation civilly, even if the charges aren't bigger than they wished.
All right, we're joined by Andrew Fleischman. Of course, we'll be keeping you updated on this story with every development that we learn and bring that to you right here on Atlanta News First. We're taking you now to the Atlanta News First newscast at noon for your latest top stories and what's been happening in and around Metro Atlanta. Thanks for joining us.